Okay, so you talk about the components of an objective legal system. Can you summarize those?
Sure, and I guess I would put it a little bit, I don't know, well, sounding like a philosopher. I don't know if I'd use the word components, but yeah, I talk about three critical factors or pivotal factors in thinking broadly, at least, about objectivity in a legal system. Essentially, what the system does, how it does it, and why it does it. Why in the sense of what's the authority by which it does what it does. So I could say a little bit more about each of those. When I say objectivity is a matter of what the system does, what are its rules? What is the substance, the content of its laws, of the do's and don'ts that it prescribes for the people, and of the, I mean, crucially, the do's and don'ts for the government, right? What powers does it give the government? What powers does it not give the government? So the content of the law is the what. It's got to get that right in order to be fulfilling its function. Then the how of the legal system. Its manner of administrating all of this, of putting this into practice. And that encompasses a great deal. And this is not the glamorous stuff. This is the, to some extent, behind the scenes. How do we decide on who's going to be the government personnel? In City Hall, in the State House, in the White House, wherever, right? How are we going to make laws? How are we going to change laws if we ever do that? How are we going to enforce the laws? Punishment decisions. What's going to count as evidence? Also, so there's a whole range of things that simply concern putting the laws into practice, putting a proper system into practice. That's the administration. Really important because even if you have really well-designed laws that in content do exactly what they should do and nothing else, if you fumble the implementation, you're not going to get the benefit of those. You might actually get some very damaging harms as a result. But really, the third pivot, which I mentioned last, is in a way the first. It's why is the government doing what it's doing? What is its authority for doing that? The answer to that question, I think, is really what tells you what the content should be, and then from there you can figure out the best way to implement this. So I do find that a useful framework, and it was very helpful in thinking about that, simply to really keep my mind on what's the function of the legal system overall? What's the reason for which they have this coercive power?
So let's talk about a little bit the relationship among those, right? You use the term form follows function, I think, which I think is a good term. And we've heard the idea of both the substance of the law and the process of the law, or you could maybe call it what the laws say and how they convey their meaning versus what they're supposed to do. Is it fair to say that most people, when they talk about objectivity in law or rule of law, are really focused more on what I would call the process of it, what the laws say, how clear the laws are, whether you have recourse to the courts, that kind of thing?
I think you're right. I think that most people, to the extent that they ever attend directly to objectivity of law, I think you're right. I think they have their mind primarily, almost exclusively on these more administrative or process, procedural aspects of the law. Well, you didn't write that clearly. Or you didn't apply that equally to all parties or impartially. And I mean, that's an important element for an objective legal system, but we need to think about it, and this is something Ayn Rand talked about. She doesn't talk about objective law a lot, but in some of the places where she does, you have to get the content right in the first place. And I think today, most people are more comfortable bracketing the controversial stuff. Can't we just bracket that? We'll just go along with these laws that we have, or the laws that the people want, and objectivity kicks in there.
I think that in itself is a kind of fascinating thing. And I want to read a quote from the book to convey what I would say is, I mean, it's a radical book. You're making a radical argument, which is a good thing.
Thank you.
I don't think it's a bad thing. But let me read this quote, and I'll comment on it and get your view. So the quote is, quote, "The most crucial component of objectivity in a legal system, because it stands at the base of all the rest, is the authority by which that system rules. The system must be morally justified in wielding its power. Without this, at the legal system's foundation, neither the content of its rules nor the manner in which it administers them could be objective." So My first good quote, by the way. There's a lot of good quotes like
Thank
that.
you.
It's like if I want to write a review, and I'll just, I can do a lot of pull quotes. But this is a radical thing to say. So, and I think you know that. I certainly know it. I mean, nobody else says stuff like this, and this is not what people talk about.
Not nobody
for the most
else,
part.
but yeah.
Well, very few. And I can tell you, at least from the practitioner standpoint, the idea that we care about a thing called morality in the law is taken as like sort of crazy.
Right. You're revealing yourself to
yeah,
be,
and I mean, in a sense, it's taken as non-objective. It's taken as you're introducing your own opinions into the law, right?
That's how it's taken, right?
So what I want you to do is, and I want to unfold and spend some time talking about this because I think this is one of the most important points that you're making, is why is that? You touched on it a minute ago. Let's push aside all the controversial stuff, right? But give us a sense of why do people... why is the idea that we're going to talk about the purpose of government and morality or the authority of the law anathema? Why is it something that nobody wants to deal with?
Well, I mean, in a way, that's a profound question about our culture, and just our discomfort with, again, in part, the controversial stuff or the stuff that we know people are going to disagree about hotly, and emotionally and so on. But this idea that values are subjective, that it's all just opinion and it can't be resolved, but we have to get along in the world. That sort of pragmatic attitude, but come on, we have to make contracts, we have to have traffic run and so on. But most people, I think, no longer believe in the objectivity of values. Now, at the same time, they're quite ready to complain if coercion is used in ways that they think is wrong. So even while we were saying earlier, very few people will talk directly about the objectivity of law, particularly about its content, they know non-objective law when they see it. They're quite ready to charge that was bias, that was favoritism, that was, partiality on the part of judges or courts or whoever, or legislators or whoever it might be. So, I mean, we want our cake and to eat it too. We want the proper use of government power, but we don't want to say what makes it proper. Yeah. I mean, in part, what I'm saying is, that's ridiculous. Again, given what you're doing is forcing people. I mean, whether you're forcing them to give $1, whether you're forcing them to give their life, whatever the penalty the government is attaching on some behavior, you need moral license to do that. This guy's life is his, right? Big news. That's another argument. That's what I talk about in the first book on moral rights, right? But if this guy's life is his and this woman's life is hers, you, government or anybody else, may not touch her unless you have moral authority. So it just seems to me what I'm doing is saying, let's pay attention to that thing we have to pay attention to if the law is going to be, if the rule of law is going to be different from the rule of Tony Soprano or the mafia or whoever's got the most power in this neighborhood or this nation, right? If there really is a difference there, and I think most people in this country, well, they do still think there is a difference, but they just feel like, well, I can't really make the argument, or people get so hot and bothered. We've got to try to understand what is that moral foundation so that we can get the laws right.
So I'm glad you mentioned Tony Soprano.
And I am Italian, so I'm allowed to say that.
Yes. Well, because the word that comes, the phrase that comes to my mind is might makes right. Right? And people may not think that this is a premise of our legal system, but it really is. And I want to read you a couple quotes now, and I want to get your reaction.
Now, wait, which is a premise of
might makes right. It is implicitly, and I'm going to make the case for this, but I want your reaction on some of this. So I want to read you a couple quotes from the famous case Lochner versus New York, and it's Oliver Wendell Holmes's dissent, and I know you're familiar with this. And part of the reason that it's worth reading, now this case came out in the early 20th century. It's about a century old. Why does it matter today? Well, here's one reason. In the gay marriage case that came down at the end of last term, Justice Roberts, in his dissent, relied on Lochner like 19 times. This is Lochnerism. It's the idea that the courts are imposing their views on our democratic system, and they have no right to do that. So it's become a famous sort of staple or background idea in our legal system. It goes to a number of the ideas we're talking about, among them the idea that our laws are value neutral, and that's kind of what I want to talk a little bit about. But I can't resist making the connection between Oliver Wendell Holmes and Tony Soprano, because I think they're birds of a feather. But anyway, so let me just read you a couple of quotes here.
That's
I want to
a
get
very good
your sense of this. So this is from the Lochner decision, and it involved a challenge to a maximum hours laws of bakers, but ultimately it was the court striking down a law that restricted people's freedom. And here's one of the things he said, quote, "I strongly believe that my agreement or disagreement has nothing to do with the right of a majority to embody their opinions in law." Give me your sense of, give me a comment on that, because I think it goes to a lot of...
might makes right.
Yeah.
That is as un-American as you can get. And what I mean by un-American here is it's against the American Constitution.
Yeah.
I don't mean it's against some vague nebulous spirit. It's against, excuse me, Mr. Holmes, it's against American bedrock law, which is the Constitution, which is a document clearly dedicated to the idea that the majority, whatever, unbound, unqualified, the majority gets whatever they want. No, that's not the system we have. That's the system some other places have, right? So that, again, I think that is completely faithless to the U.S. Constitution, which all justices swear to uphold, and it is might makes right, which is the antithesis of no, right makes right.
Yeah.
Morality determines what is right in the realm of law, the rightful use of government power.
Now, is it fair to say that you would call that idea that's captured in that Holmes quote that I just read non-objective? And if so, explain that to the audience.
Yes, I do think it's non-objective. Oh boy, to explain it is kind of complicated.
Okay.
And I'm not sure if I can, I know I can't do it quickly.
Well, is it fair? Let me, I can, go ahead, if you want to go ahead.
Well, let me just say a little bit. Ultimately, just as legal philosophy, I think, is an outgrowth of political philosophy. Political philosophy itself rests on certain conclusions of moral philosophy, which themselves depend on certain conclusions of metaphysics and epistemology. So when we say that objectivity in a legal system demands getting the content right, the substance of laws, the what of laws, as I put it earlier, right? The way to figure out what those are, what is the right content, is going to require, again, looking back at what's the purpose of government and the function of government. And that, we can say here very quickly, I think the purpose of government is to protect individual rights, but that requires an argument. Now, I go into that somewhat in one of the chapters of the book. I go into it much more depth elsewhere, but that's, again, that's a whole, it comes from conclusions about the needs of human beings, the needs at the most foundational level for freedom, so that we're able to exercise our rational faculties, so that we're able to do things to meet our needs. And again, that's a much bigger argument, but it's ultimately, I think that's the grounding for saying, objectively, we need a legal system to do this, and then in order for it to do that, we need laws that do this, this, and this, and no, not that.
Yes, so is it fair to say, though, that this is a kind of an example of form-following function in a legal system? In other words, what the function is ultimately tells us what the form of our laws should be.
Yes, I think it is an example of that. And function is very, very helpful. And that's one of the things I learned. I appreciate more having worked on this book, how useful the what for, that question in any field, the what are we doing this for? Why are we giving these people this power? So the function is very helpful. It still leaves questions. It doesn't answer in detail all of the questions, but it tells you the right questions to ask, and it gives you very helpful guidelines, I think.
So a related topic is the idea that law should be value neutral. And one of the people you mentioned earlier is Judge Bork, who was, thankfully, in my view, never Justice Bork. And he wrote a famous article about the First Amendment, its neutral principles and the First Amendment. I think he was a big proponent of this idea that yeah, you can have, as long as you have clear laws, they're not retroactive, everybody gets to go to court, it doesn't really matter. It could be in the Soviet Union, it could be in America, it could be in Iran, big deal.
Yeah.
And you actually have people who, from Harvard and other, they go to other countries and they advise them on their laws and they say stuff like this. So you've written about the idea that it's inescapable. Values are inescapable in the law. Can you touch on that just a little bit? You cover it in the book, and you also cover it in some law review articles.
Yeah. I mean, in a way, it's essentially, I think, what I've already been saying about, look, the use of coercion requires justification, moral justification. But I do talk about, I have a whole chapter on the rule of law where the particular emphasis is on the rule of law is not a value-neutral ideal. And that is the prevalent, the dominant understanding among scholars. That is, the rule of law, a legal system, that doesn't need to be moral. It just needs to be clear, not retroactive, have these formal but supposedly non-moral characteristics. And yeah, I think it's a really dangerous idea. Now, there are some other people who are on my side on this. I'm not alone here by any stretch. But the dominant idea is it's value neutral. Again, to some extent, I think this is motivated by the wish to avoid the controversial disputes. So we can help you, Iran, Afghanistan, Putin's Russia, we can help you have a better society by just following these formal ideas of the rule of law. One of the things I ask in arguing against that is, how would you even know which so-called formal, value-neutral, value-empty conditions to impose on a legal system without presupposing, right, at least implicitly, some idea of what you want that legal system to be accomplishing, to be doing. So there's no way around, I think, value questions. But unfortunately, that has become such a prevalent idea, and among smart and well-meaning people. So I do go into that in a lot more depth in the one chapter and in an article as